trying to keep my world record speed meeting going here. So I'm going to move forward. Let's back up to approve amendments to RPC 1.11 proposed by the Committee on Professional Ethics. We have Chair Pam Anderson, and I understand we now have Subcommittee Member Brooks Holland, who will give us a presentation on that issue.
Yes, Brooks, you can go ahead. I think you've already been kind of introduced in the process, but for those who might have missed this is Professor Holland, and he is an esteemed member of our committee, and he's going to present on the proposed amendment to RPC 1.11.
Thank you, Pam. Thank you, governors, for the opportunity to share some additional thoughts on the proposal that's in your materials on this amendment. It's a fairly small amendment to comment to Rule 1.11 in a similar vein to a recent proposal we brought to you at one of your last meetings to upkeep the rules of professional conduct to some recent Supreme Court decisions that are carving out small exceptions or nuances to the rules of professional conduct by case law. You may recall we came to you recently following the Carstetter case to seek some small signal additions to the comments in rules 1.16 and 1.13 for that particular issue relating to the ability to sue for prospective contract loss. Here we have an issue relating to conflicts of interest for government lawyers in the case of State v. Nichols. In Nichols, the issue involved a former client conflict for the county prosecutor in Grant County. Under Rule 1.11, typically government lawyers' conflicts of interest with a former client would not be imputed to the rest of the government lawyer office. So you could remove the individual lawyer with the conflict and the office still could handle the case. Screening is recommended, but we don't have the traditional imputation of the former client conflict to the entire office to disqualify the office. In the Nichols case, the court held that when the government lawyer with the conflict is the elected county prosecutor responsible for all of the lawyers in the office, that conflict will be imputed to all the other lawyers in the office, and therefore the entire prosecutor office will be disqualified from the conflict of interest of the elected county prosecutor. They did not change the rule for the other government lawyers in the office, just for the elected county prosecutor who has supervisory authority over all of the other prosecutors in the office. We talked about how far in depth we might want to go in addressing this issue in the rules of professional conduct. We concluded, similarly to how we treated the Carstetter case, that a brief note in comment 2 as a signal to lawyers who might be dealing with a county prosecutor or a similar government lawyer with a conflict of interest should suffice. So you see just a brief citation in a parenthetical. I will note we got a comment from Governor Dresden asking whether the CF signal to introduce the citation perhaps was the clearest signal, because CF might suggest that it's consistent with the general rule. And as we all get further and further from the Blue Book, even we professors delegate a lot of that work to the law students. I think that's probably a good comment to consider, and maybe a but CF might be a more accurate one to signal to lawyers that Nichols actually offers something that departs from the general rule outlined in comment 2. So with Pam's permission, maybe I'd suggest that we could take that comment as a friendly amendment to the proposal from the Committee on Professional Ethics. But bottom line is we're just looking to place a signal in comment 2 so that lawyers who encounter conflicts of interest that are the conflicts of the chief prosecutor in a particular office know to look at the Nichols case in evaluating how to proceed.
Thank you, and I apologize. I should be referring to you as Professor Holland. Thank you. I'm going to open this up to questions for the Board of Governors, and I see Chief Disciplinary Counsel Doug Ende.
Thank you, President Cicchetti. I'm disappointed, although pleased, that Governor Dresden beat me to the punch on the CF citation. I did want to make the point that the CF site introductory signal is a fairly abstruse one as among introductory signals. And it is never used, not once, in the model rules of professional conduct or the Washington rules of professional conduct. So I'm not sure we should start now with using the CF introductory signal. And since really Nichols heads in the opposite direction from the immediately preceding assertion, which is conflicts are not imputed in government offices, but in this one instance, they are. A but-see introductory signal might be the best choice here, and that is an introductory signal that is used in the rules of professional conduct. Thank you.
Thank you, Chief Disciplinary Counsel Ende. That this discussion has just got too cerebral for me.
Now that we realize the CF is nowhere in the RPC, almost want to put it in there for the first time even more. But I think a but C also would be a friendly amendment from my perspective. Pam, I'll defer to you.
I certainly would endorse that, since that was my original suggestion before the committee decided. So I will use my authority as chair to accept that as a friendly amendment.
All right, with that amendment changed. All right, looking back to my little blue hands, any other questions or comments from the governors? Governor Dresden, did you want to comment on CF as well?
No, I think the friendly amendment covers it, and if there's no further discussion, I would move that we approve it.
All right, I have a motion.
I'll second that.
And I have a second from Governor Clark. All right, and I'm going to say one more time, any further discussion? Hearing none, we'll proceed with a roll call vote. Governor Abel. Governor Angeville.
Aye.
Governor Boyd.
Aye.
Governor Clark.
Aye.
Governor Dresden.
Aye.
Governor Grabicki.
Aye.
Governor Higginson. Governor Higginson. Governor Kang. Governor Knight.
Aye.
Governor McBride.
Aye.
Governor Peterson.
Yes.
Governor Pertzer.
Aye.
Governor Williams-Ruth.
Aye.
Governor Higginson. Ten in favor, no noes, no abstentions. My perfect game continues. Thank you, Professor Holland and Chair Anderson. Appreciate your presentation today, and good luck moving forward with this rule amendment.
Thank you so much. Have a great weekend, everybody, and good luck with the rest of your meeting.
All right, thanks for your attention to this.
You bet. Thank you.